Can a deity be a juristic person? In other words, can a god or a goddess be an entity recognized by law as having rights? Arguing before the Supreme Court Constitution bench, hearing the challenge to the ban on entry of women between the age of 10 and 50 to the Sabrimala shrine in Kerala, a lawyer for an intervener held that Sabrimala's Lord Ayyappa is a juristic person with fundamental rights, and his right to remain a Nastik Brahmachari falls under Article 25 of the Constitution, and so the entry of women inside the temple should continue to be restricted. Contesting this argument, lawyer Indira Jaising, representing the petitioner, said, "There is a distinction between juristic personality and a citizen insofar as claiming fundamental rights is concerned. A deity being a juristic personality is nothing but the right to sue and be sued in its own name, does not give them the rights under Article 21. Now, the framing of this argument, one of the many made before the Constitution bench, underscores the complex legal issues the bench will now rule on. The Supreme Court on Wednesday reserved its verdict in the matter. Up ahead, we look at the 5 questions in the Sabrimala case under the consideration of the Constitution bench. It's Thursday, August 2nd. Karnataka Chief Minister H.D. Kumaraswamy is faced with his first prickly political issue since coming to power. A demand for a separate state for North Karnataka is being made in some quarters, a demand that many believe is being fueled by the BJP. Alleging discrimination by successive governments, a group of outfits have called for a bandh in the 13 North Karnataka districts today. Some groups have claimed the region has been given stepmotherly treatment in the state budget presented last month. Others point to low representation in the cabinet. Now, North Karnataka is made up of Mumbai Karnataka and Hyderabad Karnataka. Mumbai Karnataka has over time emerged as a BJP stronghold. The Congress is strong in Hyderabad Karnataka, and the JDS dominant in South Karnataka. Kannadigas opposed to any talk of bifurcation took to Twitter, writing with the hashtag Karnataka Vonde, meaning Karnataka only one. BJP legislator B. Sriramulu, close associate of the infamous mining scam accused Bellari brothers and someone who has pitched his lot with the statehood demand, was targeted. Political analyst D.P. Satish writes that this sudden demand for a separate state has nothing much to do with the aspirations of the common people in Mumbai, Karnataka and Hyderabad, Karnataka, and more to do with the BJP looking to consolidate itself. One has to understand the Karnataka unification movement, he says, to realize the BJP's game plan. Most Kannada-speaking areas came under one administration in 1956 as Mysore state. It was renamed as Karnataka in 1973. The unification demand came from the North Karnataka regions of Mumbai, Karnataka under the Bombay Presidency and Hyderabad, Karnataka under the Nizam's rule. There was strong opposition to unification of the Kannada-speaking areas in Old Mysore region. The Old Mysore state was a well-developed state, and the southerners were not ready to share their wealth with the underdeveloped North Karnataka cousins. And the most important reason was caste politics. It's Lingayats versus Vokkaligas. They view each other with suspicion. While North Karnataka is a Lingayat stronghold, Vokkaligas dominate the south. Meanwhile, to preempt any kind of mobilization, the Chief Minister has said his government is considering shifting some government offices to the Suvarna Vidhana Saudha in Belgavi in North Karnataka. Presently, the Suvarna Vidhana Saudha functions as the state legislature during the winter session. The Supreme Court on Wednesday agreed to hear a petition against the publication of Malayalam novel Misha. The petitioner has taken objection to a conversation between 2 characters in the book, which he alleges insulted temple-going women. Writer S. Harish had announced last week that he was stopping the publication of his novel Misha in the Malayalam weekly Mathrubhumi after protests by Hindutva activists. They picked on a conversation between 2 characters in which one of them says that well-dressed girls who visit temples are subconsciously conveying their readiness for sex. Harish said he received several threats to his life through phone calls, text messages, and social media last week. I am too weak to take on the people who rule the country, so I'm withdrawing the novel, Mathrubhumi News Channel quoted him as saying. Reacting to the threats, poet Kalpeta Narayanan said, right-wing groups have been attacking Harish for an inconsequential comment made by an unimportant character in his novel. They could not demarcate between the writer and the characters. This shows the growth of an extreme group in Kerala that cannot enjoy works of fiction. Meanwhile, DC Books has now published the novel and it hits stores on Wednesday. In 2010, when Haiti, an impoverished Caribbean nation, was struggling with devastation wreaked by an earthquake that left upwards of 200,000 people dead and flattened its infrastructure, some senior aid workers belonging to Oxfam, one of Britain's biggest charities, were busy indulging in serious sexual misconduct. The Times of London, in an investigation published earlier this year, detailed the abuse. One account talks of how local Oxfam drivers were asked to bring prostitutes, many of whom were really girls, some as young as 14, to be exploited. Now, a damning report published by the UK government says sexual abuse of vulnerable girls and women is endemic. The report quotes the British Red Cross as saying, "The opportunity for abuses of power in humanitarian contexts is high, and there is often an imbalance of power. In times of crises, during humanitarian emergencies, social protection systems can be significantly weakened and disrupted." One of the testimonies detail how a homeless girl was given $1 by an NGO aid worker and then raped. The report concludes that overall the picture that has developed over the course of our inquiry is one of exploitation and abuse, rooted in a power imbalance that is predominantly, although not exclusively, gendered, with powerful men as gatekeepers to food, shelter, and security, exploiting and abusing women and girls because they are powerless, they are vulnerable, and they are voiceless. Does the restriction on the entry of women into Kerala's Sabrimala temple amount to discrimination? Is the exclusion of women an essential religious practice? These are some of the complex questions the Constitution Bench of the Supreme Court is considering as it concluded the hearing in the matter on the entry of women into one of India's biggest pilgrimage centers. Let's get you a brief background. Women between the ages of 10 and 50 are not allowed in the shrine. It is widely believed that is because the presiding deity Ayyappa is celibate. The temple's management had earlier told the Supreme Court that women of menstruating age can't be allowed on account of purity. The petition in the Supreme Court points to an earlier decision of the Kerala High Court in favor of the practice to underscore how it was, among others, based on gender stereotypical premises that women are impure and polluted during their cycle of menstruation. In October last year, a 3-judge bench of the Supreme Court had framed a set of 5 questions for the Constitution Bench to consider. Let's try and understand them. First, whether the exclusionary practice, which is based upon a biological factor exclusive to the female gender, amounts to discrimination and thereby violates the very core of Articles 14, 15, and 17. Articles 14 and 15 pertain to equality before law and the prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth. Article 17 bans the practice of untouchability. Lawyer Gautam Bhatia had inferred that, in framing the question, therefore, the court has at least acknowledged the possibility that banning women on grounds of menstruation creates and perpetuates a stigma that is similar in character to the stigma faced by caste untouchability. Second, whether the practice of excluding women constitutes an essential religious practice under Article 25. Now, Article 25 states that all persons are entitled to the right to freely profess, practice, and propagate religion, subject to public order, morality, and health. Now, the essential religious practices test first found mention in a 1954 case in the Supreme Court. The court here said what constitutes an essential part of religion will be ascertained with reference to the tenets and doctrines of that religion itself. So the question before the court: is the banning of menstruating women an essential religious practice or a peripheral one? Third, whether Ayyappa temple has a denominational character, and if so, is it permissible on the part of a religious denomination financed out of the Consolidated Fund of Kerala and Tamil Nadu to indulge in such practices violating constitutional principles? Now, Article 26B is where the Constitution guarantees every religious denomination the freedom to manage its own affairs in matters of religion. So can Sabrimala, which is governed by the Travancore Devaswam Board, which is a state institution, be considered a religious denomination? Questions 4 and 5 are connected, whether Rule 3 of the Kerala Hindu Places of Public Worship permit religious denomination to ban the entry of women between the age of 10 and 50 years. If so, would it not fall foul of Articles 14 and 15, which is restricting the entry of women on the grounds of sex? The Rule 3B of the Kerala Hindu Places of Worship rules is ultra vires of the Act itself. In 1965, the Kerala Hindu Places of Worship Authorization of Entry Act was enacted. Under Section 3 of the Act, places of public worship must be open to all sections and classes of Hindus, notwithstanding any custom or usage. Section 4 deals with the power to make rules for the maintenance of order and due observance of religious rites and ceremonies, provided that no rule or regulation shall discriminate in any manner whatsoever against any Hindu on the ground that he belongs to a particular class. Under powers of Section 4, the Kerala government frames certain rules. Rule 3 bars certain classes of people from offering worship, and this includes women at such time during which they are not by custom and usage allowed to enter a place of worship. So the question being asked here is, doesn't this rule barring women run contrary to the main act, which throws open places of worship to all sections and classes of Hindus? Net, these are complicated legal questions, which in effect will decide if Article 26B, the right of a religious denomination to manage its own affairs in matters of religion, can be allowed to override the individual freedom of women to freely practice religion as guaranteed under Article 25(1).